I had been on this bench long enough to know that some cases do not arrive looking dangerous. They come wrapped in paperwork so ordinary that if you blink, you miss the human damage hiding underneath. A parking citation, a municipal code issue, a small administrative dispute that should have been corrected in one decent conversation before breakfast. And then the child walks in. That is when the disguise falls away. The morning Emily Turner entered my courtroom, the room was already carrying the kind of silence that tells you people sense trouble before they can name it. Emily was 14 years old. 14. She sat at the plaintiff's table with both hands clasped tightly in her lap, shoulders rounded inward, the posture of a child who has spent too many weeks apologizing for something she never did. Beside her sat her mother, Sarah Turner, a woman with the unmistakable face of working exhaustion. Not theatrical distress, not courtroom performance, real fatigue. The kind that settles behind the eyes of women who live on schedules too full, paychecks too thin, and sleep too short to absorb one more unnecessary blow. Across from them sat Officer Daniel Price. If you glanced only once and too casually, you might have mistaken his posture for confidence. Arms crossed, back broad against the chair, expression calm. But when you do this work as long as I have, you learn the difference between confidence and contempt. Confidence answers questions. Contempt waits for them to finish. He had the second one. He looked at Sarah and Emily the way some people look at paperwork after a long day. Something inconvenient that should have been processed quietly and disappeared. I asked the clerk to call the case. Petition involving improper citation, escalated fees, and related harassment. Sarah Turner versus Officer Daniel Price. Now, let me be clear. Judges are not supposed to enter hearings already angry. We enter attentive. We enter suspicious when necessary, but not angry. Anger clouds listening. What sharpened me that morning was not emotion. It was the sight of a 14-year-old girl in a courtroom over a parking ticket she could not legally have caused because she was not legally allowed to drive. If that sentence sounds absurd, good. It should. Absurdity is often the first clue that laziness and authority have joined hands somewhere upstream. I asked Emily her name and age first because I wanted the room anchored in the basic truth before anybody started hiding behind procedure. Emily Turner, 14 years old. Then I asked her one simple question. Were you driving the car? No, ma'am. Were you in the driver's seat? No, ma'am. Passenger seat? Yes, ma'am. Was the car running? No. Were you alone? Yes. My mom told me to lock the doors and wait. That should have been the end of the matter right there. It should have been enough to expose the stupidity of what followed. But bureaucracy has a remarkable way of surviving on momentum long after common sense has died. Sarah testified next. She worked mornings and picked up evening shifts when she could. On the night in question, she had stopped at a grocery store after a long day because the house needed milk and she needed headache medicine. The lot was crowded. The weather unpleasant. Emily was tired. Sarah told her to stay in the car, lock the doors, and wait. It was a decision millions of parents make in 7 ordinary minutes without imagining the law might somehow be waiting outside to turn that choice into a crisis. 7 minutes. That was all. When Sarah came back, Emily was crying. The ticket was under the wiper, and Officer Price was already moving away. Emily had opened the window only enough to ask what the paper was. According to Sarah, and then according to Emily, he told her the car was standing illegally and the driver had failed to move when instructed. The driver. That word kept coming back like a bad smell. I asked Sarah what happened after that. At first, she thought it would be easy to fix. She called, explained that her daughter was 14, that the car was off, that she had only stepped inside briefly, that the sign itself was partly blocked and difficult to see from the angle where she stopped. She expected a human being somewhere in that system to hear the story and say the obvious thing. This should not have happened. Instead, the opposite happened. The ticket remained. Then late fees were added. Then administrative charges. Then, because Sarah could not pay it immediately without sacrificing something else her family needed, the amount grew. One bad act of judgment by an officer became a month-long siphon running straight into a household already stretched too far. That was when I asked the question that always matters in low-dollar cases. Not what did the paper cost? What did it cost you? Sarah took a breath and told me. The original amount was painful but manageable if she skipped enough things. The added fees were not. She fell behind. An overdraft followed when one payment hit earlier than expected. Groceries tightened. Bills shuffled. Emily overheard every conversation. Every strained whisper over the kitchen table. Every tired sigh after the mail arrived. The child began apologizing for all of it. She stopped drawing. Stopped sleeping well. Started saying she had ruined everything. That is what bad public judgment does when it lands on private families. People talk about tickets as though they are pieces of paper. They are never just paper to a household balancing on the edge of solvency. They are stress translated into mail. Then I turned to Officer Price. He said he had followed protocol. That phrase has protected more foolishness in this country than almost any other. Protocol. As though the existence of a form excuses the disappearance of a brain. I asked him to explain exactly what he thought he was doing when he wrote a citation identifying a 14-year-old passenger as the responsible driver of a parked vehicle. He said the vehicle was in a no-standing zone and had not been moved. I asked him whether he understood that a 14-year-old child could not lawfully move the car even if she wanted to. He said the code did not reference age. That is when I knew the problem was not confusion. It was indifference. So I opened the file my staff had prepared because by the time this case reached me, it was no longer only Sarah's word against an officer's. My researchers had done what overworked mothers cannot be expected to do between jobs and dinner and laundry. They checked citation patterns, complaint histories, body camera logs, municipal code cross-references. And what they found was not an isolated mistake. It was a pattern. Over the previous months, Officer Price had issued multiple citations in that same high-yield curb zone under circumstances that raised serious questions. A disabled mother unloading groceries while displaying a placard he later claimed not to see. A delivery driver cited while collapsing from heat exhaustion. A pregnant woman ticketed after pulling over because she became dizzy and was later transported to a hospital. In each instance, paperwork existed. In each instance, explanation followed. In each instance, the same defense appeared. Procedure. Volume. Efficiency. The language of someone no longer seeing people, only quota opportunities. And in Emily Turner's case, the pattern deepened into something uglier. Not merely indifference. Cowardice. Because children make easy targets when they have been taught to obey authority, even when authority is wrong. I asked Officer Price whether he wished to reconsider his description of himself as simply following policy. He did not. Men like him often cannot imagine the floor giving way until it already has. So I laid out the evidence one piece at a time. First, the citation itself identifying a non-driver child as refusing to move the vehicle. Second, the municipal language showing discretion available to any officer with common sense. Third, the signed photographs demonstrating visibility concerns. Fourth, the complaint history revealing a striking tendency to enforce against distracted, vulnerable, and isolated individuals unlikely to mount immediate resistance. Then I asked him the only question that mattered. Did you actually speak to Emily as a child needing adult assistance? Or did you approach her only as a source of a ticket? He gave no meaningful answer because there was none to give. At that point, the courtroom understood what I understood. This was not about parking. It was about judgment. And specifically the absence of it in the one person on that curb entrusted with public authority. I turned back to Emily then because while adults argue about procedure, children absorb blame. That is almost always the hidden emergency in cases like this. I asked her whether she thought any of this was her fault. She nodded before catching herself. That broke my heart more cleanly than tears would have. Children in trouble often cry. Children who have quietly internalized false responsibility do something worse. They apologize with their bodies before they say a word. Emily had been doing that for weeks. So I told her clearly and in front of everyone that she did nothing wrong. Not one thing. She sat where her mother told her to sit. She obeyed. She waited. She did not cause the ticket. She did not cause the fees. She did not cause the fear in that house. Those belonged entirely to the adults who failed around her. The room changed when I said that. Sarah cried. Not loudly. The kind of crying that comes when the truth finally lands where panic has been sitting. Emily cried too, but differently. Relief has a way of looking almost painful on a child's face when she has been carrying guilt that was never hers. Then I issued my ruling. The citation was void. Every fee attached to it was void. Every collection action, processing charge, and administrative consequence triggered by that citation was void. I directed the clerk to clear the record completely. Then I made the second part of the ruling, the part that mattered beyond one family. I ordered the full file, including the complaint history and my findings from the hearing, referred to Internal Affairs and Departmental Command Review for examination of Officer Price's enforcement pattern. Because a badge is not a hunting license, and public order is not maintained by selecting the vulnerable as easy paperwork. That would have been enough in many courtrooms. But enough is not always what justice requires. Sometimes justice also requires naming the moral center of the wrongdoing, so nobody in the room walks away pretending the issue was technical. So I said what needed saying. Authority without common sense is dangerous. Authority without compassion is worse. An authority used against a child because the adult holding it cannot be bothered to think is contemptible. Officer Price looked smaller then, though he had not physically moved much. That happens sometimes when people realize their posture is no longer doing the work they expected from it. The room had stopped granting him the visual authority he walked in wearing. That is one of the few useful powers a courtroom still has. It can strip pretense down to conduct and leave a person standing only inside what he actually did. I do not know what happened in his department after that beyond what the formal process allowed me to see. I know the review moved. I know the file did not disappear. And I know at least one family, Sarah and Emily Turner, got their life back from a piece of paper that should never have existed. But what stayed with me most was not his face. It was Emily's. Because here is what people who have never lived under financial pressure do not fully understand. A false ticket does not enter a struggling household as an inconvenience. It enters as weather. It changes the atmosphere in every room. It changes the way the mother sounds when she opens a bill. It changes the way a child interprets silence. It changes dinner, sleep, homework, breath. It teaches fear to spread sideways. One officer's laziness can become a child's private shame for weeks. That is why public servants are required to use judgment and not merely process. The margin for thoughtlessness is small when other people's lives are this tight. After the hearing, Sarah thanked me more times than necessary. People often do that when the system has frightened them long enough. They thank the person who stopped it, even though the system should have behaved correctly before my bench was ever needed. I accepted it because gratitude from the overburdened is often less about the judge and more about relief itself finally being allowed into the room. Emily did not say much on the way out. She just looked back once, as children do when they are trying to decide whether to trust what has just happened. I have seen that look many times. It asks a question no child should have to ask. Is it really over? This time at least, the answer was yes.